All right, good morning. This is under indictment 08-04-0441. Counsel, your appearance, please.
Good morning, Assistant Prosecutor Mike Luciano for the state.
And Cheyenne M. Cushing-Muriel, would you state your name for the record, please? Your attribute for the record, please.
Cheyenne M. Cushing-Muriel on behalf of Marrakesh Empire Aboriginal Law.
All right. I want to ask you a couple of questions, please. The first question I want to ask you is, are you employed?
Objection, man. This hearing is supposed to be about jurisdiction. This court has no jurisdiction. The court has no jurisdiction to determine its own jurisdiction for a basic issue in any case before a tribunal.
Well, if I have no jurisdiction to determine my own jurisdiction, how are you going to get that issue resolved?
Listen, this case in this courtroom is a culpable, incompetent court of jurisdiction. You can't, according to federal case law, you can't set another hearing to reach and determine your own jurisdiction. As I've stated for the record plenty of times, I'm only having threat, duress, and coercion, and because the prosecution falsely holds my property, and I'm here to clarify that matter. Other than that, I'm here under threat, duress, and coercion. It is completely against federal case law. It has power to act, and the court must have the authority to decide that question in the first instance. That's Rescue Army versus Municipal Court of Los Angeles. A departure by a court from the recognized and established requirements of law, however close apparent adherence to mere form and method of procedure, which has the effect of depriving one of a constitutional right, is in excess of jurisdiction. You have the flag right behind you, ma'am.
May I interrupt you for a moment?
You may not, ma'am.
And would you, when you're done speaking, would you let me know so that I can ask a question?
I'm not obligated to answer any questions, so I have no intentions of answering any question.
Well, I'll ask it anyway, and you can decide what you want to say.
Thus, where a judicial tribunal has no jurisdiction of the subject matter on which it assumes to act, its proceedings are absolutely void in the fullest sense of the term, Dillon versus Dillon. Courts enforcing mere statutes, as it is to my understanding, that this is a statute, not a constitutional violation of law. In fact, one of the hearings I had with you, you said people are not charged with constitutional violations. I don't understand how you could be enforcing statutes and you have the U.S. flag behind you, as if you hadn't taken an oath to uphold the Constitution. Courts enforcing their statutes do not act judicially, but merely ministerially. Thus, no judicial immunity, and unlike courts of law, do not obtain jurisdiction by service of process, nor even arrest and compelled appearance. Boswell versus Otis. I've been here 3 or 4 times on the threat, duress, and coercion. Prosecution doesn't even have folders in front of him. He has no objections. He has nothing to say. He cannot prove jurisdiction. This court should have been dismissed this case. This is a culpable court of incompetent jurisdiction. The fact that petitioner was released on a promise to appear before a magistrate for an arraignment, that fact is circumstance to be considered in determining whether the first instance there was a probable cause for the arrest. Monroe versus Popper. There's no discretion to ignore the lack of jurisdiction. Court must prove on the record all jurisdiction facts related to the jurisdiction asserted. A universal principle, as old as the law, is that proceedings of a court without jurisdiction are a nullity and its judgment therein without effect either on person or property. This case has already been put before the federal court, and you will be receiving a notice of removal very shortly. This court has no jurisdiction. Prosecution can't prove jurisdiction. This case shall be dismissed, and it will.
Did you file a notice of removal with the federal court?
Yes, you will be receiving it shortly.
All right. When I receive it, I will rule on it. This is my question to you, however. Are you employed?
I'm not employed. I'm not employed with any corporations incorporated with the state of New Jersey.
Are you employed with any corporation that's incorporated outside of the state of New Jersey?
Objection. I'm not here to answer questions about my employment. Last time I was made aware of this was supposed to be about whether this court has jurisdiction, and clearly it doesn't. A question about employment has nothing to do with whether this court has jurisdiction, so I'm not obligated to answer those questions. Now, I shall not be answering any more of those questions that are not pertaining to jurisdictional facts.
Well, this is my question to you. I asked it before. If your position is that this court has no jurisdiction to determine its own jurisdiction.
Objection, man. That is not my ruling. That is not my holding. I've given you the federal case law regarding such. Maybe you can take some time out that you need to do to recheck that, but that's what the case law says. It's not what I said.
Well, I do have jurisdiction over you. Number one, you're here in my courtroom.
Objection,
Number
ma'am.
two,
You do not have jurisdiction over me. I'm here by way of threat, duress, and coercion. The federal case law stipulates already that compelled appearance and arrest warrants doesn't give a minister acting ministerially and not judicially enforcing their statute's jurisdiction. That's incorrect and false. You do not have jurisdiction because I'm here. You told me before when I was here that you would lock me up if I didn't come, which was threat, duress, and coercion.
I think that you misstate what I told you.
Objection, ma'am. I have not misstated. I have the videos. I have it on repeat 24/7. I've seen you say it.
I don't recall that I said I would lock you up.
Well, objection, ma'am. That's on the record.
Well, you can object all that you want, sir. You and I will continue to have a difference of opinion about that. All right. Well, we'll continue with today's proceedings then. And I certainly appreciate the courtesy that you extend to me. All right, Mr. Walker, I know that you are here. You wish to be heard, sir?
Your Honor, I have Kevin Walker appearing on behalf of the Office of the Public Defender. We did receive after the last hearing a court order directing the Office of the Public Defender to represent this defendant. I did file a motion for reconsideration, noting that there has been no indigency determination, which is an essential component of our appointment. So I would ask respectfully that an indigency determination be made at this time, absent that earlier order directing to represent this defendant be vacated.
All right, thank you. Do you wish to be heard on the issue, Mr. Luciano?
I don't think so.
All right. I have inquired of Cheyenne Mutada Kushamirel concerning his employment. He tells me he is not employed in the state of New Jersey by any corporation, and therefore I determine that he does not have the present ability to pay for counsel to proceed in this matter.
Objection, ma'am. I don't know this gentleman. I haven't made any contracts with the Public Defender's Office. I don't know what that was an attempt to do, but he does not have the authority to speak for me. So I would appreciate it if any non-identified parties determining to act on my behalf first fill out an IRS Form 56 and notify the IRS that they're acting in some sort of fiduciary capacity.
All right. Let's talk about the issue of, Mr. Walker, I want to talk about the issue of jurisdiction. One of the issues that has been raised in this case and has been raised over and over again that really needs to be determined before we can proceed with it is with regard to jurisdiction. I have received, it was filed with the court, it was received in my chambers on January 7th. I'm not exactly sure if it was filed downstairs on a different day. Something that has been entitled a non-negotiable affidavit of fact to dismiss with prejudice for lack of personam jurisdiction, lack of discovery, and lack of an injured party. It purports to raise the issue before the court of lack of jurisdiction with regard to Cheyenne Mutada Kushamirel L. Despite what Cheyenne Mutada Kushamirel L says, this is not an application to the court to dismiss anything with anything. There are certain ways, as you are aware, Mr. Walker, to bring issues before the court. What we need to do is have the issue brought before the court properly by way of a notice of motion. I don't even know if Mr. Luciano got a copy of this, but certainly you know that any motion filed has to be served on the prosecutor. How much time does your office need in order to do that? And did you receive a copy of this?
As I have not received a copy of that, and before I address that issue, I would respectfully request that you inquire into this defendant's assets to see whether he has a present ability to retain private counsel.
He tells me he isn't employed by a corporation, so...
Objection. This is obscene.
Sir, this is a conversation that I'm having with Mr. Walker, not with you. And the way you didn't want me to interrupt you, I would like you not to interrupt me or Mr. Walker.
Objection. This man cannot speak for me, man. I haven't filled out any public defender's applications nor contracts to agree to that. You cannot force me against my consent to have someone who has, I have no